Dr. Ibiang Livinus is currently a public health and biosafety expert and a professional in politics with over 19 years working in the social sector to strengthening institutional reforms that can lead to social changes. He has led several students and youth movements and have been involved in human rights advocacy. He was a former FCT interim chairman of Alliance of New Nigeria Party, ANN, and it was under his leadership that the party built the structures at the local government and world levels before his ascension to the office of the National Vice President of the party for the South-South Zone after the National Convention in 2018. In his capacity, he served in several committees, prominent amongst which is the Security Committee, which he chaired, the Partnership Committee with other parties for the general election in 2019. He was also a member of the National Campaign Council of the party and served as the South-South Zonal Director and Chairman of the National Campaign. Dr. Ibiang is a graduate of the University of Calabar and holds several certifications in his chosen field. He holds, in addition, a master's in business administration from Ahmadu Bello University and also a PhD in international public health. He sits on the board of trustees of your one and only Electoral College Nigeria and Electoral College Africa by extension. Ladies and gentlemen, kindly welcome Dr. Livinus Ibiang. You have the floor, sir. You're highly welcome.
Thank you very much, Samsudeen, and good evening, everyone. And once again, I'd like to take the opportunity to congratulate each and every member of this cohort for the steadfastness and focus and for sitting in all of the different presentations up to today. We cannot overemphasize the very importance of political education, what we call politeracy in Nigeria. If you pay attention to some of the narratives across both social media and conventional media, you'll find a huge knowledge gap amongst politicians. This include governors, appointees, elected legislators, and down to local government administration in Nigeria. So there is a huge gap when it comes to politeracy, and that's why the Electoral College was butted, and kudos to the founder and executive director of the Electoral College, my very dear brother, Kunle Lawal, for betting this initiative that will definitely outlive a lot of us. And through the instrumentality of the Electoral College, so many have gained knowledge and have also taken steps to venture into the murky waters of politics, and armed with the knowledge that they have acquired from the different cohorts that the Electoral College have bettered. So once again, I welcome you. And I want to also thank the leadership of the Electoral College and the management of the college as well for the great work that they've been doing in building the capacity of the teeming Nigerian population in the area of political literacy. Please confirm you can hear me very well. Excellent.
Yes, sir, we can.
Excellent. Okay, thank you. Thank you. So today we will be looking at history of constitutional development in Nigeria, and our focus will be from the pre-independence era, noting from 1914 to 1999. And of course, we will talk a bit about some of the constitutional modifications or amendments that have taken place in the past few years since the Fourth Republic. Just a bit of background to note that the history of constitutional development in Nigeria is one that is essentially the story of how the country basically moved from traditional governance mechanisms that were in place through British colonial rule into independence. And this, of course, had witnessed multiple military and civilian transitions, as we are, of course, going to see in the course of this particular lecture, to arrive at the 1999 Constitution that has become the ground norm by which we are governed today. So therefore, I will attempt to provide a bit of clarity and structure in a chronological manner, just so that we are able to appreciate that it's been a long journey to where we are today. And to so many who perhaps may not have had the opportunity to look back in time, to actually introspect where we're coming from. This, of course, will be an opportunity for that to happen. My lecturer those days used to tell me that the lectures we receive in the universities are largely 20% classwork, and the remaining 80% is research. So what it means is that you get a guide in class from the lecturer, but then 80% of the work is still the responsibility of the student. And I can understand why that is so. It means that you have a great deal of work to do. Beyond what you learn from here today, and of course, which you have learned in the course of this commencement of this particular cohort, I will encourage us to go back, dust up what we have learned from the different presenters, and also look up some of this information just to equip us. The internet today is replete with a lot of information, and there's a lot we can get. We have only tried to make available to you as much as possible what will give you the fundamentals to be able to get integrated in the political firmament of this country. Having said that, so the pre-colonial period, can we have the slide move to the next? So the pre-colonial period looks at the period before 1861. And I'll just mention a couple of things before we go deep into looking at today's work. We have what we call the Protectorate of Northern Nigeria and the Protectorate of Southern Nigeria. The Protectorate of Southern Nigeria is a product of the unification of the colony of Lagos. And of course, Calabar was also a colony. And then the protectorate to form what you call the Protectorate of the South, Southern Nigeria. And it's instructive to know that the Northern Nigeria has some sort of centralized emirate system, which was under the Sokoto Caliphate, governed through Islamic, or what you call Sharia law. So that was the law that guided the governance of the northern region. And this is, of course, at variance with what we have in the southern region, which, as I have indicated earlier, has some sort of traditional governance system. So especially within the eastern part of Nigeria, where you have more of a republican, decentralized republican system. And in the southwest part of Nigeria, we have what seemed like a traditional parliamentary system, where you have the Alafin, who sits like the executive, and of course, you have the Council of Oyomesi, who are responsible for providing advisory insight into governance to the Alaafin. So that's the kind of systems we have in the pre-colonial era. Now, so as we've all seen the outline, now it's important to define certain terminology and very important just to set the structure for today's lecture. To begin with, we are looking at constitutional development. And so it will be important for us to understand what exactly is constitution. So constitution is a fundamental legal document that outlines the principles and laws governing a country or organization. So it's a legal document because it's a product of, law of the parliament, and which is, of course, as you know, the parliament is the representation of the people. It is a microcosm of the general population, which is why when you open the constitution, the very first paragraph usually would read, "We the people." So a testament to the fact that it is a product of the people living in that defined geographical enclave. Now, some scholars have gone ahead to look at what the Constitution is, and citing the works of Oyediran, professor, who noted that in his words, not only that the Constitution is descriptive of the allocation of powers between levels of government and various positions and responsibilities, he said it is also legalistic in nature, affirming the fact that the Constitution is a legal document. Now, a renowned constitutional lawyer, Ben Wabweze, Prof., posits that a constitution is an act of the people, which I've said earlier. And if it is made by them, and you could see the way he qualified it, and we'll come to that. And some, of course, may have picked on that very phrase, if it is made by them, either directly in a referendum or through a convention or constituent assembly, popularly elected. That is according to Wabweze. So you can see that both scholars have given very important perspective with respect to what the Constitution is. So drawing from all of that, we can then hold that the Constitution is the ground norm and serves as the supreme law of the land. And this is because it sets forth the framework of government. And this includes the structure, which speaks to the arms of government, how government is organized, the branches of government, the powers and responsibility allotted to the different branches of government as contained in the Constitution. The second part is functionality, and this speaks to lawmaking process, implementation, enforcement, and of course, interpretation. And if you look at the functionality of the Constitution, you will see clearly how the powers are shared according to the different arms of government. For instance, if you talk about the lawmaking process, that is fundamentally the functions of the National Assembly that we have. That is at the national level. And then, of course, the state houses of assembly at the state level. And at the local government level, we have the local government legislative council. So all of these have the sole responsibility for lawmaking as contained in our Constitution. The implementation and enforcement of the Constitution is also the function of the executive. And the instrumentality, there are various instrumentality of the state that empowers the states to be able to enforce and implement the law. And then the business of interpretation is that of the judiciary. So this is how the government functionality is defined within the structures of government, otherwise referred to as the branches of government. Now, what else does this constitution prescribes? The constitution prescribes the principle of governance. And within the principles of governance is what we call the rule of law. Without the rule of law, we can't be talking about governance. So when you talk about governance, you speak to basically orderliness, maintenance of justice, enforcement, lawmaking, observance of the rule of law, because there are fundamentals of the rule of law as contained in Chapter 2 of our Constitution, which speaks to the directive principle of state policy, and under which you have all the rights of the individuals who come together to agree to have or enact the Constitution by which they will be governed. The other principle of governance is the principles of separation of powers as proposed by Baron Montesquieu. And according to him, the different branches of government are designed in a way that they are able to check one another in order to avoid tyranny against the governed. And so, while the lawmakers make law, they cannot implement the law that they make. It is the business of the executive to implement the laws made by the legislature. Now, while the executive implements or enforces that law, it is the business of the judiciary to interpret and arbitrate on the laws that have been made. So this is the principle of separation of powers that Baron Montesquieu envisaged in his work, and that this exists so that there is balance within the branches of government, and no one organ or arm of government is bigger than the other. And you begin to wonder, so if the three arms of government, the legislature, the judiciary, and the executive are on the same level, how comes it seems like the executive is the all and all in Nigeria? Again, that's a big question. I'm sure that will already be generating some, perspectives in our minds. So we'll keep that, and during interaction, we may perhaps, talk about all of that. Now, what other thing is prescribed in the Constitution? We have the rights and freedom, and which includes the fundamental rights of individuals, to include individual liberties, the rights such as freedom of speech, assembly, and religion. Of course, there are so many. This is just an example. If you look at Chapter 2 of the Constitution, you find all of the rights that the individuals are meant to enjoy in the Constitution. Now, the other thing that is prescribed or circumscribed within the Constitution is the amendment procedure. So the Constitution prescribes within it the mechanism for its revision or amendment, as the case may be. And then, of course, it defines its supremacy above any other law. So the Constitution is the supreme law of the land. But of course, you will be wondering, why must it assert supremacy? Yes, there are other laws, and I'll give you some example. Practically, we have what we call delegated legislation. Delegated legislations are instruments, okay, by which the state is governed. And these instruments are developed by the executive arm of government. That's why it is called delegated legislation. And some of which include policies, executive orders. I'm sure you've heard of executive orders. So executive orders are law. They are delegated legislations. Okay? guidelines by which different agencies of government are governed. They are all delegated legislation. Don't forget, the business of legislation is that of the legislature. But then we have delegated legislation. And so the whole idea, and also the states also have powers to make law through the state houses of assembly. And then the local government also make laws, which are called edicts at that very lower level. Now, the whole idea of emphasizing the supremacy of the Constitution is that where any law, whether made by the local government, the state houses of assembly, the National Assembly, or delegated legislation by the executive, is inconsistent with the provisions of the Constitution. The Constitution says that that other law shall, to the extent of its inconsistency, be null and void, thus invoking the supremacy or establishing the supremacy of the Constitution, which we have all established is the ground norm of the country. Now, I've taken my time to provide this additional information. You will not find it on the slide that you have there, but I'm sure you're listening and taking down notes just so that we have a rich background to what we have on the slide. So, next slide, please. Who is navigating?
Charlie, please, next slide.
All right. So now, remember I mentioned earlier that we want to look at two historical contexts. One is the pre-independence Nigeria, and the other is the post-independence Nigeria. So pre-independence Nigeria, the pre-independence Nigeria featured 5 constitutions that were adopted at different periods of our historical evolution. And we'll be looking at them. But first, let us establish something. In 1886, for instance, there was a charter that was granted the Royal Niger Company. So RNC stands for Royal Niger Company, to administer the protected territories in northern Nigeria. That was where the British colonial government actually started. Nigeria was basically like a product or one of the fields, that's why they call it protected territories, for the Royal Niger Company. The Royal Niger Company is actually a company doing business. So they got instruments from the British government to administer these protected territories that have been conquered at the time on behalf of the British government. So they got the charter in 1886. Now, in 1899, the Protectorate of Northern Nigeria was established. There is a difference between protected territories and protectorate, as it were. So the Protectorate of Northern Nigeria was established in 1899, following a revised charter. And then we had what we call the Oye River Protectorate, which was established in 1893 and later changed to the Niger Coast Protectorate. We are getting somewhere. And then the Southern Protectorate was proclaimed. Don't forget that I mentioned in my intro that initially Lagos was a colony of its own. Calabar was also a colony of its own. And then you have the Oye River Protectorate, which of course later became the Niger Coast Protectorate. All of these were later fused together in 1900 to form what we call the Southern Protectorate. Now, in 1906, there was the first attempt to build a nation when the colony of Lagos and the Protectorate of the Southern Nigeria were amalgamated into the Protectorate of Southern Nigeria. In 1912, Sir Frederick Lugard, a very popular name which we all know and can relate with, returned to Nigeria, to the geographical enclave called Nigeria, as the governor of both the Protectorate of Northern Nigeria and the Protectorate of Southern Nigeria. At this time, don't forget, Nigeria was not yet formed, so it was two protectorates. And then in 1914, there was the amalgamation of Nigeria as a colony of the British Empire and as the Protectorate of Nigeria by Sir Lord Lugard. So it was in 1914 that the name Nigeria was then proclaimed, and it became one protectorate of the British Empire. Next slide, please. So, having said that, these were some of the major developments of the pre-independence era. Of course, we have what we call, not many persons consider this as a constitution, but some scholars feel that it should be held so because there were instruments by which the protectorate of Nigeria was governed. And so it's important to look at that as well, which is why I had put that up as Sir Frederick Lugard Constitution of 1914. So let's look at some of the key provisions of the instruments or the charter by which Sir Frederick Lugard administered the Protectorate of Nigeria. One, the Lugard Charter provided opportunity for the expression of public opinion through a non-legislative Nigerian council. That council was purely advisory. It was purely advisory. So it was saddled with no powers to make any law. So only matters of interest during the year were discussed at the time. So it's not necessarily what the Nigerian representative in that council wants to discuss. It is what the British government consider of interest to them that were discussed in that council. So they were the major drivers of policy at the time. So the Nigerian Council consisted of just 36 members, including 6 Nigerians nominated to represent the coastal districts and the interior of the country. And these 6 Nigerians consisted of 2 emirs from the north, then the Alafin of Oyo, and 1 member each from the colony, because these 2 were colonies, ab initio, from Lagos and Calabar. And these were major seats of colonial governance in Nigeria at the time. And then we have the Benin Warri area. This information, of course, you can obtain from the Federal Information Service of 1955. And then Lord Lugard's term ended in office ended, and Sir Hawk Clifford assumed office as the Governor General of Nigeria in 1922. And when he came on board, he established what you called, popularly known as the Clifford Constitution of 1922. Now, some of the key elements of the Clifford Constitution include the first formal constitution in Nigeria. Remember, some scholars have indicated that the Lugard Constitution cannot actually be termed to be a constitution, but we felt that there is a charter by which the Protectorate of Nigeria was governed, and it's instructive to actually mention that, so we get a sense of how Sir Lugard governed Nigeria during his time. However, the real constitutional development actually began with Sir Hawk Clifford, and that constitution was styled the Clifford Constitution. So the Constitution created what you call the Legislative Council with limited representation, largely made up of educated elites who actually exercise some voting rights as guaranteed by that Constitution. And it was basically aimed to address the overbearing colonial governance at the time, but then it lacked broad political participation. Just as mentioned, it was largely the elites that made up the members of that council. So the whole southern Nigeria, the new council legislated for the whole of the southern Nigeria, and it could also debate on estimates of the whole country. So that's looking at budgetary estimates. Now, if you dig deep, you find why this is so. And we won't go into that, but just to give us a sense of what the provisions of those key provisions of those constitutions were. Then it provided for a total membership of 45 as against what we had under the Lugard's constitution. So we had a membership of 45, and it consisted of 26 official members and 15 nominated members. Now, according to Oyeleye, for the first time in Nigeria at the time, Lagos and Calabar were granted the right to vote in an election to the Legislative Council. Now, if you cast your minds back to when we talked about political parties and structure, I did mention that franchise at the time was granted to the colonies of Lagos and Calabar. And that was because of the provisions of the Clifford Constitution, which provided for Lagos and Calabar to be able to vote and elect people into the Legislative Council. So whereas there are members of the council that were elected from the colonies of Lagos and Calabar, others were nominated from other parts of the country. So very interesting development. Again, don't forget we're talking about the history of constitutional development in Nigeria. Now, 3 seats were allotted to Lagos and 1 seat was allotted to Calabar. Now, apart from Lagos, it shows the status of Calabar as an intellectual center at the time. It should also be noted that Calabar was the capital of the Oil River Protectorate created by the British in 1891. So that is why Calabar was the seat of governance of the British government at the time. And for those who are from Cross River and those who have had the opportunity of visiting Cross River State, the Cross River State Government House is called the Lugard House till date. And this is because the seat of government was around that area. Very interesting, So next slide. So those were the key elements of the Richard's Constitution. And then after Sir Richard came Sir. So again, sorry, just a moment, please. So after Clifford, we had the Arthur Richards Constitution in 1946. So Sir Arthur Richard took over from Sir Hawk Clifford, and when he came on board, what he did was to also evolve his own constitution. So, and what were the key elements? The constitution established the executive and legislative councils and then expanded representation in governance. And this is largely because Sir Richard's recognize the diversity of ethnic nationalities in Nigeria. He noted that there are nationalities from the north, the south, and of course, the eastern regions. And with each region, of course, having its own regional council, which were largely hamstrung as the laws for the regions were centrally made by the Legislative Council. So Richardson did an attempt to expand representation in governance, and given the diversity that he observed in the country at the time, allowed for the establishment of regional councils. However, these councils were quasi-councils because they weren't really making legislations for the governance of the region as such. The legislative authority was vested in the Legislative Council at the national, which was governed by the British Empire. But of course, that's some sort of, progress already made. From just a small group of people we had in Clifford expanded to 45, and then in Sir Richard's constitution, we have more representation. And we'll see the numbers as we, progress. So the regional councils were granted full legislative status, but then it set the stage for increased political engagement and the regional autonomy, at the time. Now, it's important to note that despite this, there was growing awareness within the Nigerian elites. And this growing awareness resulted in, very serious criticism of the Richardson constitutions. And this, according to the elites, was largely because there was, limited consultations with the elite. Don't forget that the Nigerian elites at the time were already becoming, they were politically very conscious. In the words of a popular former senator, he said they were politically sagacious, so, and they begin to interrogate a lot of things. And this, of course, precipitated some, changes that we'll eventually see in our constitutional evolution. Next slide, please. So, following the criticism of the Richardson Constitution, Richardson's term ended, in office ended, and we had Sir John Mafferson, who took over the reins of affairs in 1951, and of course proposed what is known in history, in Nigerian history, as the Mafferson Constitution. Now, what were the key elements of the Mafferson Constitution? One is the Order in Council number 1172 of 1951, which established a central legislature made up of a single chamber. So you can see how we are devolved, called the House of Representatives. So Mafferson Constitution is what established the House of Representatives at the national through an instrument called the Order in Council. The slides have been taken down. Can we have them back? Okay, good.
It's back up.
Okay, thank you. So we had the regional houses represented by 136 members. Then there was an executive council consisting of the chief commissioners of each of the three regions: the Attorney General, the Financial Secretary, Director Medical Services, Director Education, and others nominated by the governor. This was according to Omu in his work in 2005. Now, the Mafferson Constitution also approved bicameral legislature for the western region of Nigeria and the northern region, which of course, laid the foundation for an improvement to what we had during the Richardson Constitution. Now, for the first time, Nigerians were made ministers, but without ministries or portfolios, which was seen by many as a setback to our manifest destiny. So a lot of Nigerian elites kicked against this because people were just appointed minister, but they do not have portfolio. So they were just roaming around the place. In other words, they do not have executive authority, as it were. Now, the Mafasin Constitution provided for establishing more political parties like the Action Group and MPC. So if you go back to um, the political parties and structure lectures that we had, you will agree with me that it was in this time of 1951 that the Northern People's Congress was established. And then, of course, we had the Action Group, which was a product of Oboema Oduduwa at the time. So you could see how which constitution actually, provided that enabling environment for political activities to actually evolve in Nigeria. There are shortcomings of the Mafasin Constitution because it didn't last long. And some of the shortcomings include the fact that the northern delegates in the Central Legislative Council refused to support the motion that was moved by Chief Anthony Nahoro of Action Group in 1953 that Nigeria becomes self-governing. Okay? And while the members in the South saw it as eventful and historic, the Northern members saw it as an attempt by the South to set in motion some sort of political hegemony. And this was the reason, they kicked against it. And look, let me say this. If you look at our National Assembly today, if you must pass a law that favors a particular state or region, you will have to do a lot of consultation and engagement with other legislators in the National Assembly. The whole idea is to have a bipartisan consensus towards a legislative agenda, either proposed by the leadership or by any region. Failure to do that would eventually result in the death of such a legislative proposal. And this is the reason for, consultation. So you could see that whatever you find happening in the National Assembly today is certainly something that has happened within our body polity in the pre-independence era. Okay? Now, next slide. So, what were some other developments of the pre-independence era? Following the criticism of the Mafasin Constitution and its shortcomings, we had Sir Oliver Littleton, who took over in 1954. And you could see that Mafasin Constitution was actually short-lived because his time was very short in Nigeria. 1951, just 3 years to when Sir Littleton, Oliver Littleton, took over. Now, interesting developments under Sir Oliver Littleton. The Littleton Constitution was a product of public resentment and protestations against the Mafasin's Constitution, which created a quasi-federal structure because you have executives, commissioners who are appointed at the federal level without portfolio. So Nigerian elites were really upbeat about, that kind of system. So there were lots of criticisms. So there were 2 constitutional conferences that took place about this period. The first in London and the second in Lagos. But both were under the auspices, of course, of the British government through the British Secretary of Colonies. So within this period, Nigeria became a federation comprising 5 units made up of the northern region, the eastern region, the western region, the Federal Territory of Lagos, and the southern Cameroons. So southern Cameroon used to be part of Nigeria. For some of you who were very much here in the late 90s to 2000, you of course would have witnessed serious debates around the ceding of an area called Bakassi in Cross River State to Cameroon. A lot has happened that resulted in that. Also, say an offshoot of the civil war that took place in Nigeria. So there were lots of, give and take that happened at the time. And of course, when Sir Herbert Macaulay in 1923 led the formation of the NCNC, the National Council of Nigeria and Cameroon, it was largely because admin, can you mute that person, please? Thank you. So Nigeria basically used to have Southern Cameroon as part of Nigeria until it was ceded off to Cameroon. So that's actually what this year. And then we... Please. A 188 members. 188 members that were mostly to be directly elected by the electorate. So you can see how we have evolved from merely appointing people into the legislative councils to now electing the representatives of the people into the legislative council, the House of Representatives at this time. And then the creation of a Federal Council of Ministers, which members are to be selected from amongst the members of the Federal House of Representatives. So clearly you could see that Nigeria operated a parliamentary system of government because the Executive Council was appointed from amongst the members of parliament. And then we had the allocation of legislative powers to the 2 tiers of government at the federal and regional level, which means that the regional councils that were created under Sir Richardson now had some legislative autonomy and power. Remember, under Richardson, it wasn't so. It was more of a quasi-legislative structure with the powers of the Legislative Council at the center dictating what happens in the region. But under Littleton, these were clearly circumscribed within the Littleton Constitution. So according to M.Y. Zachary, the Constitution created a parliamentary system of government for the country. Next slide. Great. Now, still within the pre-independence era, we had the 1957 conference. Remember, we said that 2 conferences took place, one in London and the other in Lagos. Now, the 1957 conference, which held in London, what were the key issues? The first constitutional conference held in London between May 23 to June 26 of 1957. The major issues that were discussed were around the creation of states like the Midwest states, Cross River states, and the Middle Belt states. And then, like the Western and Northern regions, the Eastern region also got a bicameral legislature at the Conference. So bicameral legislature was approved for the Eastern region at the 1957 London Conference. And then the Eastern and Western region became self-governing immediately after the conference, while the Northern region became self-governing in 1959. So that was how the different regions obtained or exercised the autonomy to govern during the pre-independence period. Now, next slide. Then we had the 1958 conference, which held from September 29 to October 1958 in London. And the main issues for discussions were the recommendations of the Minorities Commission. And this commission, of course, was set up in 1957 conference. So one of the things that came up in the 1957 conference, which I didn't highlight, was the complaints by the minority ethnic groups. Don't forget that under Sir Hawk Clifford, there was a recognition of major ethnic blocs in Nigeria. But the fact that there were major ethnic blocs does not presuppose that there weren't other ethnic nationalities in existence. So while the major ethnic blocs were gaining the kind of recognition they were having, the minority groups were raising complaints or observations on the issues of exclusion in governance. So it came up as a very critical issue for discussion at the 1957 conference in London. So during that conference, the Minority Commission was established to look at the issues of the minority and provide some recommendations in the subsequent conference. So that other conference was the 1958 conference, where the report from that Minority Commission was actually received. So there were recommendations of the Minorities Commission. And this commission actually made an attempt to address the fears of the minorities by the majority groups like the Igbos, Hausas, and Yorubas. Now, the issue of self-government of the Northern region also came up for discussion. Like we said, whereas the Western and Eastern regions became self-governing after the 1957 conference, the Northern region only became self-governing in 1959 or later on. And this was, of course, the reason why it came up in the 1958 conference. Now, the request for independence, which Nigerian delegates had made to the United Kingdom government at the 1957 conference, also came up in the 1958 conference. And the conference was attended by 106 persons, variously classified as delegates, advisors, and officials. Now, interestingly, the conference recorded decisions on fundamental human rights, the police, self-government for Northern Nigeria, position of Lagos, the Southern Cameroon issue came up for discussion, and electoral, of course, arrangement. Fiscal policy arrangement were also discussed. And then, of course, the minority problems and Nigerian independence was also discussed in 1958. Major highlight was then the Colonial Secretary, Alan Lennox Boyd, who presided over the conference, declared the promise of Her Majesty's government to grant Nigeria independence in October 1, 1960. So it was indeed the defining moment for that 1958 conference, the fact that it was, made clear that the British government, through the Queen, was going to grant Nigeria independence in 1960. Although there were two major constitutional conferences that preceded the Constitution, it retained some trappings, and this speaking to the Independence Constitution of 1960, of colonial document, which include the following. Now, don't forget that we've been looking at the pre-independence era from 1914 down to 1959. And then the Independence Constitution was then established in 1960, the very year that Nigeria gained independence. And what were the key elements of that constitution? Clearly, the constitution retained some of the elements of the previous constitution, that is the Littleton Constitution. The constitution appointed Her Majesty the Queen of England as the head of the executive judiciary, as well as being a member of parliament. So the Queen was still the one administering Nigeria. It also established two chambers of the federal legislature, that is the Senate and the House of Representatives. So what we now know as the Senate and House of Rep was a product of the Independence Constitution of 1960. And then the Constitution set forth the Nigerians' transition to self-governance and independence from British colonial rule and as a republic. Of course, that happened later in 1963, and we'll come to that. So the office of the Prime Minister, who was to be appointed by the Governor General, representing Her Majesty, the Queen, in the Federation, was also created. Don't forget, we said the Littleton Constitution established the parliamentary system because we had those appointed as ministers appointed from within the legislature, from the members of the House of Representatives who were elected. But the 1960 Constitution, of course, established the bicameral legislature, which today is operational in Nigeria. And then the Nigerian Police Force was also created by the Constitution. Then the Constitution also shared powers between the federal government and the regions that were created at the time. So those were some of the very interesting things that happened in the pre-independence Nigeria. So from 1960, we are now looking at independent Nigeria because Nigeria became independent 1st October 1960. So, that's a date that we all know and relate with. Now, in 1963, Nigeria became a republic, and the Republican Constitution was bettered in 1963. What were the key provisions? One was the establishment of a republic. So the Constitution transformed from what it used to be, a monarchy, okay, under the British Crown, to a republic within the Commonwealth of Nations. And this officially ended the role of the British monarch and established the office of the president as the head of state of Nigeria. Now, it's also set forth a federal structure, which includes, which speaks to federalism, as well as the regions, which was divided into four: the northern, western, eastern, and of course the Midwest regions of the country. The Constitution also established the presidential system, no more monarchy as it was before this time. And within the presidential system was the establishment of the executive branch, with the president as the head of state and government, with significant executive powers. The president was also elected by an electoral college, which included representatives from the region. And then we had the prime minister. So the role of the prime minister was abolished in that constitution because we had the president who assumed both executive and ceremonial roles. We had the parliamentary system, which of course include the legislature. And we did say that the legislature is made up of the Senate and of course the House of Representatives. And then we had the judiciary. So those were the key elements of the Republican Constitution. Of course, there are other provisions. Like I said, these were just some of the key modifications we had within that Constitution. Next slide. So we had that system until 1966, and of course, we know what happened in January 1966. We had the first military coup which of course removed the government at the time. And then we had the counter coup, which took place in 1966. Now, this, of course, ushered in military in the governance of Nigeria. And I dare say that during the military government, there have been several attempts to midwife constitution for the Federal Republic of Nigeria. So we had the 1966 coup, and then we had a counter coup that took place, and the country remained under military rule down until 1979. And there were, constitutions that were midwifed by the military regime at the time. So sometime in 1978, under the leadership of General Olusegun Obasanjo, a constituent assembly was put in place to midwife a constitution for Nigeria. And it is that constituent assembly that, of course, established the roadmap for the return to civil rule in Nigeria. And do not forget that following the counter coup, we had General Yakubu Gowon, who became the military head of state, and he ruled for almost throughout the Civil War, which lasted from 1967 to 1970. He was in power, and down to somewhere in 1976, when he was overthrown by the military, and General Murtala Mohammed became the head of state of Nigeria. And General T.Y. Danjuma was the chief of army staff, and Olusegun Obasanjo became the chief of staff, supreme headquarters at the time, more or less like the second in command to Murtala Mohammed. When Murtala was assassinated in a military coup led by Dimka, Sukai Muka Dimka, General Olusegun Obasanjo became the head of state of Nigeria, and he governed Nigeria after that, from when that coup happened down to 1979. And in midwifing the 1979 constitution also saw to the transition to civil rule, during which time Alhaji Shehu Shagari became the president of Nigeria, and the vice president was Dr. Alex Ekweme, all of whom of blessed memory. So they became the civilian government that took over from Olusegun Obasanjo in 1979, and they governed to 1983. And it was in the course of their second term that they were also overthrown by the military junta of General Muhammadu Buhari in late 1983, just immediately after the elections. Can we have the next slide, please? So, so these were the key elements of the 1979 Constitution. As you can see, there is not much difference. Basically, the 1979 Constitution provided a pathway for the transition to civil rule in 1979 under the leadership of General Olusegun Obasanjo, head of state of the country as he then was. And the federal structure, of course, established in the 1963, the Republican Constitution were retained, the presidential system were retained, the bicameral legislature were retained, and so also were the judicial system, made up of independent judiciary, and of course, at both federal and state courts were also established. Next slide. Next slide, please. Please go back. So we had the military rule that toppled Alhaji Shehu Shagari in 1983, and they were only in office for a year and some months. That same military regime of General Muhammadu Buhari was toppled by that of General Ibrahim Badamasi Babangida in 1985. And General Ibrahim Babangida became the head of state of Nigeria. And during his time, he made attempts to midwife a constitution, which of course we don't reference because it was never passed into law. And that was the 1989 constitution. And the reason for midwifing this was to actually to set forth the transition to civil rule in the Third Republic. Okay. And following that, that process was inconclusive. And then we had the transition to democratic governance, which of course was truncated in 1993. You recall that we had the June 12th election, which held in 1993, very popular elections. And those elections were superintended by General Ibrahim Babangida. So what he did basically was to establish two popular political parties, the Social Democratic Party, SDP, whose candidate was Chief MK Abiola, and then we had the National Republican Convention, NRC, which candidate was Alhaji Bashir Tofa at the time. So both of whom contested that elections of June 12th, 1993. And why June 12th became a watershed in the annals of this country was largely because the elections were adjudged to be the, very free and fair elections, but were annulled by the military regime of Ibrahim Badamasi Babangida. And as a result of this, having in all the elections, Babangida, of course, at the time was under pressure to hand over the reins of government because people were already getting tired of military rule. And so what he quickly did was to set up what they call the interim national government headed by Chief Ernest Shonekan. And within the Nigerian constitution at the time, there was no provision whatsoever. It was never envisaged that a structure like interim national government would be established in Nigeria because the country was to be governed by no other means save by elections, general elections. And the elections that were conducted on June 12th were annulled by that government. So what he hurriedly did was to set up the interim national conference headed by Chief Ernest Shonekan and supported by the Secretary of Defense, who was the highest ranking military officer within the government of Chief Ernest Shonekan in the person of General Sani Abacha. Now, when he set up the interim national government, Ibrahim Babangida pulled out from the military and stepped aside as the military president of Nigeria. Now, let me just quickly mention here why other heads of states retained the titles of heads of state. It was only Ibrahim Badamasi Babangida that self-named himself as military president. And the reason was because he operated a quasi-civil governance structure made up of military and civilians. Under his time as military president, there was a National Assembly, and there were state military administrators and also state houses of assembly under his time. So that was why he self-styled himself as a military president. But all of that ended in 1993 when the interim national government was set up, and it was only in office for a period of about, I think, 6 months or so. And the reason was largely because the Constitution did not recognize interim national government. So there were several litigations against the interim national government at the time. And there was civil unrest in the country. The country almost became ungovernable because of civil unrest, demonstrations everywhere against that contraption that General Babangida put in place. As a result of that civil unrest and disobedience and litigations against the interim national government, General Sani Abacha, through a palace coup, overthrew Chief Ernest Shonekan and set himself as the head of state of Nigeria. Again, another military rule which truncated the Third Republic. And don't forget, the Third Republic was never even had at all because we didn't have an opportunity for civilian governance. General Sani Abacha ruled from 1993 to June 1998 when he died. And following his death, General Abdulsalami Abubakar, who was then the chief of defense staff and the most ranking military officer, became the head of state of Nigeria. General Abdulsalami Abubakar, of course, midwifed a transition process and also commenced the process of establishing another constitution for Nigeria. And that was how the 1999 constitution that we have today was bettered. It was bettered in the Fourth Republic. It set forth the process for the Fourth Republic. Navigator, can you take us to the next slide? I think that's about the history of constitutional developments in Nigeria. So the 1999 Constitution, as amended, is what currently is the ground norm of the country. And that same Constitution is still undergoing amendment in the National Assembly. And some of the amendments that are currently taking place in that constitution include the establishment of state police. Of course, the media is awash with all of this. I'm sure a lot of us are quite conversant with some of the engagements that are currently taking place. About 2-3 weeks ago, the Arise Media Group hosted a town hall for the discussions around the establishment of, state police, basically to canvass the opinions of Nigerians on the issue of establishment of state police. So General Salami Abubakar midwife the birth of what we today call the Fourth Republic. So the Second Republic was established in 1979 when General Olusegun Obasanjo handed over to Alhaji Shehu Shagari. That Second Republic was truncated by the incursion of military into office, and this was led by General Muhammadu Buhari and then General Ibrahim Badamasi Babangida, who then midwife the transition to the Third Republic, which was, aborted even before it was born in 1993. And then again, another military incursion led by General Sani Abacha. And following his death, General Abdulsalami Abubakar midwife, of course, the birth of the Fourth Republic. So as of today, we are still in the Fourth Republic because Nigeria had witnessed successful transition from one civilian administration to another, beginning from Chief Olusegun Obasanjo, who came back to office as the president and head of state of Nigeria from 1999 to 2007, handed over to Alhaji Musa Yar'Adua, who died in office in 2010, following which Dr. Goodluck Ebele Jonathan became the acting president in 2010 to conclude the remaining term, 1-year term left of the Musa Yar'Adua administration. And then in 2011, he contested and won elections as the president of the Federal Republic of Nigeria and governed till 2015. In an attempt to contest for a re-election in 2015, he lost out to the coalition called the APC to General Muhammadu Buhari in a very historic election that saw him conceding defeat even before the votes were counted. He, of course, in his gentleman's nature, he said his elections is not worth the blood of any Nigerian, and so he wasn't going to contest whatever observations there may have been during that election. So he considered defeat and called in General Muhammadu Buhari to congratulate him. And that was how Muhammadu Buhari became president of Nigeria and ruled Nigeria from 2015 to 2023, when Asiwaju Bola Ahmed Tinubu became the president of Nigeria, and is still in office till today. So, in conclusion, Nigeria's political history, of course, is replete with major constitutional development. And despite all of these developments that we've witnessed, as we cannot see, there are ongoing challenges, issues of debates on, true federalism. Do we actually have true federalism? So that's a debate that has remained in the front burner. The issues of resource control, lopsidedness in appointments, ethnic representations in governance. These are key issues that we're currently dealing with. The need for constitutional reform to address the question of national unity and democratic governance. Of course, under Jonathan, there was an attempt to midwife a people's constitution, and that was what led to the establishment of the National Conference of 2014. However, following his loss at the elections of 2015, the product of that national conference remained in the archives on the shelf. And so we lost an opportunity of having a people's constitution. The evolution of Nigeria's constitution reflects, of course, the complexities in our history and the very huge diversities that we have all observed and are part of in the Nigerian society. So therefore, there are, quite a lot that needs to be done, which is the reason the Electoral College has enunciated this politeracy program to basically drive knowledge and understanding so that our people are able to engage productively and effectively in the governance of our country. So, ladies and gentlemen, that's what I have for us on the history of constitutional evolution or development in Nigeria. And thank you very much for your attention, and I will hand over to Shamsuddin.
Thank you for the amazing session, sir. Thank you so much. And guys, you would have to signify by show of hands to ask your questions. Please be concise and precise at the same time. You have 1 minute for every question, so Doctor can have enough time to touch on every question and further elaborate. Mr. Tunde, thank you for your proactiveness. It's highly recognized. You're welcome. You have the
Sorry,
mic,
can you hear
please.
me?
Yes, clearly.
Yeah. Thank you for this, which is quite reflective and very deep. Quick question. There was a national conference, I believe it was in 2005. I think in relation to the Constitution, and there were aspects of it that I think they wanted. I'm not sure they wanted to change. Why why wasn't it implemented? I think it was abandoned in the end. Was it the delegates who attended the conference and the conference in itself, was it only like a referendum? Was it supposed to be enforced, or was it just as an advisory? Thank you.
Okay. Let's have another question. I'll take both together.
Yeah, thank you, sir. Thank God that Mr. Tunde just talked about those constitutional conferences, and because I want to say something around that too. Over the time there have been, debate on how are we going to have more acceptable constitution in Nigeria. Now, my question is now around which do you think is likely to give Nigeria more acceptable constitution between constitutional amendment done by the members of the legislature and the sovereign national conference? That is my question, sir. Thank you.
Okay. Any other question?
Okay. Good evening, sir. Good evening, everyone. You talked about state policing, by extension, community policing. So I want to ask. We have issues of having different security agency with cross duty that in terms of the recurrence or times of their duty, we see that they are complaining they are not being funded well. You have some clashes, and now we are talking about state policing. How are we going to solve the issue of salary and other things that the federal police force is still complaining that they are not being taken care of and there's shortage? Is there not going to be a kind of problem later on that we say, okay, maybe the politicians hijack his state, or the federal are clashing that they are superior to the states? Is there anything that will be put in place in terms of that, considering the insecurity that is expanding and our security agency are still having clashes? Thank you.
All right, thank you. Let me attempt to address these three before we take others. So, yeah, the first person talked about the 2005 conference. Yeah, very true. There was a political reform conference, not a constitutional conference. It was a political reform conference, I remember, under President Olusegun Obasanjo. And that conference was headed by a retired Justice Nikki Toby. And basically what that conference was meant to look at was the issues of structure and political governance of the country. And there were also other sundry aspects, the issues of, leadership, representation, and all of that. Those good governance, ethnic representation, of course, those were things that political reform, it was a political reform conference. Of course, usually conferences of that nature are so enriched that its outcome can actually find its way in the formulation of amendments that go into the Constitution. But largely, it was a political reform conference. If you go back in history to look at it, I remember vividly it was headed by Justice Nikki Toby. So yes, there was. And the product of which, of course, would have been not necessarily advisory to the government at the time, but which was, of course, the reason why that was set up. But its products, its outcome would eventually had found its way into the amendment of the Constitution. The same way we had the Justice Ways panel, which was basically on electoral reform and all of that. You will agree with me that some of the key recommendations of the Justice Ways panel had also found its way in our constitutional amendments by the National Assembly as well. So thank you for bringing that up. It was a very important process because, like I said, whether you call it a constituent assembly or a national conference for purpose of midwifing a constitution or a political reform conference, eventually the outcome of such conference feed into amendments that will take place in a constitution. I hope that addresses your concern. And then the second question was the betting of a people's constitution, who is more likely to give to enact for Nigeria a people's constitution, whether the National Assembly or a national. So I hope I got your conference correct, but I'll just try to provide some broad context so that I'm able to address the issue of having a people's constitution. And to address this, I saw a comment that popped up on the charts. I didn't read it. And the person was saying that how true is the first paragraph, the opening paragraph of the Constitution that says, "We the people." How true is that? And that's very funny, but very fundamental. And thanks for bringing that up. So I'll put that together. Again, this is the reason why there have been a lot of debates as to the legality of the Constitution that we call the 1999 Constitution. And I'll tell you what's had been some, very significant contestation about the 1999 Constitution. I'm not trying to stir up a controversy, but just for our knowledge, do you know that the Fourth Republic was established without a constitution? And I'll tell you why. What we today call the 1999 Constitution was not a law at the time that Chief Olusegun Obasanjo became president in 1999. So those are very serious contestation. That constitution, or this constitution, the 1999 Constitution, was signed into law, if you look at the dates, after the inauguration of President Olusegun Obasanjo. So the big question is, by what law was the civilian administration established in 1999? So it puts a very serious question on the legality of the government at the time, even though there were no contestation to the government, because we all wanted a transition to a civil rule, and we had it under Chief Olusegun Obasanjo. But it's a silent, issue that remained unresolved at the time. So it was signed. If you look at the date, it was after the government was established. Now, don't get it wrong. The National Assembly has the legal authority to then, enact the Constitution of the Federal Republic of Nigeria, and which was what eventually happened. So between the National Assembly and a constitutional conference, who is most likely to give Nigerians a more people-oriented constitution? I must say, this is the reason people are against the processes of amendment of the Constitution as we have today, as opposed to having a constituent assembly or a national conference like we had in 2014 under President Goodluck Ebele Jonathan at the time. That would have given us a people constitution, because if you look at it, the representation to that constitutional conference was largely done from the bottom upward. The representatives were from, different strata of the society, okay? And both market groups, students, youths, political parties, communities, ethnic nationalities, all had representation in that national conference. What we would have had, of course, the product of that national conference of 2014 would have given us the closest to a people's constitution than what we currently have in the name of the 1999 Constitution as amended. But of course, we lost that opportunity when the key proponent of that conference lost elections in 2015. So, if you ask my personal opinion, I will tell you a constituent assembly is most likely to give us a more people-oriented, people-centric constitution than what the National Assembly is currently doing. Because if you look at the current amendments that are taking place, there are quite a lot of interest, quite a lot of intrigues, here and there, and so on and so forth. And as a result, you only get amendments that favor certain interests, as it were. So we're still going to be dealing with the issues of having a people-oriented constitution, as the case may be. And finally, the last question was the proliferation of security agencies. Now, the Constitution actually provides for the different functions of the security agencies, from the military to the police and to the DSS. Of course, the DSS have what you call the Department of State Service Act, which established the DSS. Okay, and within that framework is defined the core function of the State Security Service. The National Security and Civil Defense Corps, I think that's under the Ministry of Internal Affairs, also have clear instruments that define its structure and function. That's also contained in our statute books, and of course the Nigerian police, which is contained in the Constitution. So there's no ambiguity as to the functions of these different agencies. However, if you find clashes between the agencies, security agencies, it is largely as a result of the issues of interest, which of course is not peculiar to the Nigerian state. It's everywhere. If you take, for instance, in the United States, within the United States, you have state police, you have county police, or what you call sheriff, you have, paratroopers, different groups, and so on. At the national, of course, you have the FBI under the DOJ, that is the Department of Justice. And in certain jurisdictions, you find the FBI taking over a case. And there are certain crimes that fall within the purview of the FBI, and there are some that fall within the purviews of the state. So this is also what will happen when the state police is established. There are crimes that will fall within the ambit of the state police, whose, of course, laws will be clearly enacted by the state houses of assembly on how the state police are going to be governed, as opposed to the federal police, whose, of course, structure and function is clearly defined in the Nigerian Constitution. I think if we stick with that, there will be, less of clashes between the Nigerian police, Nigerian military, the DSS, the correctional staff, all of the different military and paramilitary organizations, including NSCDC, and of course the state police that would, come up. The issue of funding. Look, let's be clear. As it stands today, both the federal and the state government fund the Nigerian police. If you look at the huge investment that the state governors make into the police, it is obvious that even if the state establishes its own police, it can fund it. It will look at internal mechanisms to fund the police. Our state governments have quite a lot of resources at their disposal. And to what services those resources are deployed still remains a very big question, which is the reason why we ought to begin to look at what is happening at the state and not just, the federal. So we need to begin to interrogate how the state government deploys state funds in the governance of the states. There is a huge slush fund called security votes, which is at the disposal of the state governors. How do they utilize all of those? So those are questions we need to continue to ask. But make no mistake, the state has the resources to fund its police. Amotekun is funded by the states. We have different paramilitary structures in the different states that are funded by the states. So that is a clear indication that LASTMA was established by Lagos State, and it's still being funded by them. So we can also have similar structures at the state level. And the issue of whether the state's governors are going to be using the police against their political and the state police against their political enemies. Look, for me, the way I look at it, that argument still remains neither here nor there. Let's get that first established. Let's have it first, and then we'll be, modifying as we progress. Clearly, for every law, you can only appreciate a particular piece of legislation when you test it through implementation, and which, of course, is the reason why you have the popular saying that the taste of the pudding is in the eating. So let us eat it first After all, the police that we have today is used by the federal against the states. It is weaponized against the states. Look at state governors can be hounded and thrown out, okay, by the president. So let us have the state. Let the state do it and let us see how that is going to evolve, work. And I think that the people owe it. Look, one of the major sacrifices of democracy is eternal vigilance. And eternal vigilance is within the purview of the citizen to ensure that governments do not become tyrannical. And this is the reason why the citizens must be eternally vigilant and interrogate how they are governed. It is said that the citizen, office of the citizen, is the highest office of the land. How are we executing that? How are we evoking those powers as citizens to actually interrogate what governments do? Because it is a social contract between the people who are governed and those who govern. So we must begin to interrogate all of that. So to my dear sister who asked the question of overlapping functions between security agencies, I must say that interest usually is the reason why we have all of this. There's a coordination structure within the Office of the National Security Advisor who coordinates the security services. That is his function. So at the state level, we imagine that the chief security officers in the government house will also play a similar role in ensuring coordination of, security paraphernalia at the state level. So there are mechanisms in place, and until we test them, we may not know the deficiencies for us to be able to initiate popular reforms that will address those gaps. Samsudeen, over to you. Next question, if there is any.
Yeah, I'm trying to unmute Ibrahim Umaru.
Thank you.
Please, you have the floor for your question, Ibrahim Umaru.
Okay, can you hear me, please?
Yes, yes.
I hear you loud and clear. Go ahead.
Good evening, Mr. Linus. Thank you very much. This is the third time for me being in part of your class. Thank you very much for the contribution you are giving.
Thank you.
My own is constitutional amendment. That's where I think under the constitution, that's slice 3, introduction. I saw where you made mention of supremacy and amendment procedures. The set forth procedure for its amendment. So my own is there any specific agreement or cluster that says that the duration of the, like I know 2021 the constitution was opened for amendment, and I think last week or last 2 weeks I was in the National Assembly again and I was alerted that the constitution amendment is ongoing again. So I don't know, is there any timeline for that? Then in the constitutional amendment, definitely this one I can give us, because in the 2021 constitutional amendment, I was able to submit one of my memorandum in terms of amending the constitution in such a way that the ex-governors of our states should be stopped or should be banned from contesting senatorial seats in the National Assembly, considering that most of them, they take it as a retirement jungle for them, where you see ex-governors sitting in the Senate chamber, where decision making and policy that will affect the ordinary citizens of Nigeria emotion for 4 years. The number of not governors, not being governors, that's first time as a came that they are not governors before. Their performance very excellent, but most of the governors, their performance very, very low. So we submitted that. I think they removed it, and I think last 2 weeks when I did the public hearing, I was able to raise that alarm. But still, when we finished that, they brought highlights of the open week. They removed my own contribution regarding banning that or accepting that memorandum. So you as a constitutional expert, I want you to guide me through, because I'm only not the one. Like not young, not too young to rule bill. So we are moving that and like reserve seat for women. We want to move it like that so that we want a situation whereby the parliament will be a well documented and well productive parliament. So I need your advice. What advice do you have for us to take that forward? Because they're not giving us green light, they're not giving us room mostly when they bring it there. Because when I did it in 1990, I think then in the 9th Senate, the current vice president was there. The first lady, current first lady, Excellency Remi Tinibu was senator then. Aisha Tudai Birnani, all these Sokorasa. When I am doing it, they were pressing their phone. But when I come to that Article 8 memorandum where the ex-governor should be banned from, for instance, they drop their phones looking at me as a young person that, who is this boy talking this? They pick it, they accepted it, I submitted everything. When they came to read in the national, they went support, those that support the nation say I, so they say nay, they picked my paper, they put it out. So what advice and this public here, this what we call open week that held, I was open to be there. I raised my hand and I remind them on that, but they are stopping me. I don't know.
All right.
Thank you very much.
Thank you. I got your question. Is there any other hand? Samsudeen, is there any other hand?
Yeah, there's Gideon.
Okay, let's have that before I respond.
Yeah, good evening, everyone. Can you all hear?
Definitely. Yes, please.
All right. Thank you, Mr. Speaker. Thank you, our coordinator. Thank you, everyone on live tonight. My question tonight is about Prime Minister and the presidency. Up till now, some countries they still practice that system of government where you have Prime Minister and the president. One will be acting as one acts, they take the ceremonial like role, and the other person do the executive roles. So in the case of Nigeria, I think we no longer have it at the moment. So my question now is, if we are to like have that kind of system of government in Nigeria again, is it going to add more challenge, considering the fact that we have like numerous tribes and languages in Nigeria? Will it add to our political challenge, or it will foster peace and unity? Because definitely we are not going to have two people from same tribe or region, one being a president, then the other prime minister. I know that will not happen. So if you are going to have prime minister and a president someday in Nigeria, would that add to our challenge, like in terms of tribalism, favoritism and stuff, or it will foster peace and unity? Thank you.
All right, thank you. Let me quickly address yours before I go back to the first person. Now, again, you recall that the 1963 Constitution, which is the Republican Constitution, abolished the office of the Prime Minister in Nigeria and established a presidential system of government where the president becomes the president and the head of states of the country, and of course the commander-in-chief of the armed forces and police of the Federal Republic of Nigeria. So that's what we have in our constitution today. So office of prime minister ceases to exist. There are countries that practice parliamentary system of government. Now, every country decides on what system of government it wants to practice. So every country operates or defines what system of government it wants to practice. In Germany, for instance, you have what you call the German Chancellor, and the president is never seen because it's a ceremonial head. In Britain, you have the king now. It used to be the queen, but now the king. And then you also have the prime minister. So it's a parliamentary system of government. And the role of the king is, is ceremonial. And the prime minister is usually, of course, the head of government. So he runs government. So it all depends on what system the government wants to practice. And there have been questions around the expensive nature of the bicameral legislature and presidential system of government that we practice. And I think that if there is a resurgence of discussions around the expensive nature of the democratic system that we practice today, I think that there may be propositions for a different system of government that may be considered less expensive as compared to the bicameral or presidential system that we operate today. Look at our presidential system. You have the president advisor, and then of course the council of ministers, the cabinet, okay, through whom the president executes different policies of government. You have a bicameral legislature made up of the Senate and National Assembly. And the big question is, so altogether you have 109 senators and about 306 something House of Rep members, giving us about 405 members of the National Assembly. And that's a huge legislature. And the question is, what are they really doing? And there is a huge budget that goes to funding the bicameral legislature. So it's actually very, very, very expensive. And it's not only that there are elected legislatures in the National Assembly, there is also the bureaucracy within the National Assembly. For instance, just like you have the civil service of the Federation, you also have the bureaucracy within the National Assembly. So the National Assembly have the National Assembly Service Commission, which is the bureaucracy within the National Assembly, and it's also huge. So when you look at it, you can understand why it is that expensive to run the kind of system that we have today. So if the preponderance of opinion of the masses of the people is focused on the expensive nature of the presidential system of government that we implement today, then it might become an issue on the front burner as to what system of government would be more effective and less expensive, more efficient, but robust than what we currently have today. So those are things that we need to put on the balance. On the issue of whether there will be challenges, look, even the presidential system we have today has so many challenges. So the reality is that whether you're operating presidential system of government, a democracy, or a parliamentary system, or communism, or socialism, or whatever system would definitely have its challenges. Make no mistake about that. But the point for us is that, are we learning from the mistakes that we are making? Nigeria has been under civilian government from 1999 to today. We grew from being a nascent democracy. Those who were conversant with the political vocabulary at the time, I'm sure, were very familiar with the word nascent. There was the use of nascent democracy, as it were, at the time. Okay, today our democracy is still maturing. I would say it has matured. It's still maturing, but we've moved from being nascent to another level. The big question is, what are the lessons we have learned from implementing this democratic experiment from 1999 to today, and how are we applying it? So that those are key questions that we need to continue to interrogate. The other question about the first speaker on the issue of timelines to constitutional amendment. The timelines to constitutional amendment are set forth by
Very slick.
the National Assembly, defined within the broad framework of the Constitution. So the National Assembly set that timeline. First, there is a proposition for amendment. It goes through the first, second, and third reading, second reading, and then it goes out to the states, where the different state House of Assembly takes those propositions that have been discussed by the National Assembly to then look at it, look at the nitty-gritty and then pass it if they agree with it. Anyone they did not pass, they will also indicate. And it is expected that 2/3 of the state legislative houses have to pass a particular piece of legislative amendment before the National Assembly will then harmonize and then pass it into law and then send to the president for assent before it becomes or carries the force of law. So whereas there is a broad framework that is defined for this, National Assembly sets the timeline. And that's why if you look at the town hall discussions that were taking place, there's been, calls for states to actually expeditiously look at the proposed amendments and consider it and pass it so that it will come back in record time for the National Assembly to then pass it before sending it for assent. So those timelines are defined by National Assembly. The second question you asked with respect to the memo that you presented to National Assembly, frankly, the Constitution of the Federal Republic of Nigeria guarantees that every citizen of the Federal Republic of Nigeria has a right to vote and be voted for. It is a right enshrined in the Constitution of the Federal Republic of Nigeria. And if it is a right, then you can't stop anybody. That's why they keep throwing it out. So the state governors are citizens of the Federal Republic of Nigeria, and they have the right to contest for that office. So that is why that memo that you submitted was stepped down. I'm just thinking, and I feel strongly that it is on the basis of the fact that the state governors who have served the state are citizens of the Federal Republic of Nigeria in the first place. And that's why you cannot deny them as citizens from contesting from the highest office, from contesting for those senatorial positions. However, this is what you can do, and I'll share with you based on practical experience of what we did. When I was a student at the University of Calabar in 1998, we came together, those of us in student politics, we came together and decided at the time, because the Calabar municipal government, that is the local government council within Calabar, was largely dominated by, the elderly people. Even the political party was. So those of us who are students decided that we're going to carry out a revolution where we will plant ourselves in the party structure, because everybody that must emerge as a candidate or flag bearer comes through the party. So if we infiltrate the party structure and hold critical positions, we will be in a position to determine who emerges as a candidate of the party. Altruistically, if you execute this, you will be 70% ahead of determining whether a senatorial candidate who has served as governor can actually emerge as a senatorial candidate. Now, this is what we did. We were able to do that, held the party structure at that level, and we were able to determine who became the chairman or the mayor of Calabar municipality. This was 1998 come 1999. So, whereas the Constitution provides for the rights of citizens to contest office, interested parties can decide to make up the rank and file of a political party so that they will be able to determine who becomes the flag bearer of that party. I think if you take that approach, in mobilizing the youth, the market women, the students, and other interested parties, community leaders, and so on, in your place, you'll be able to actually, to a large extent, determine who represents your senatorial district in the National Assembly. But by constitution, you cannot be able to stop anybody from contesting for a position unless that person has been barred from contesting as a result of a criminal offense that that person was involved in. That's only when such a person can be banned. But as much as the person has a clear standing, that person has the right to contest for such a position. I hope that addresses your concern. So to my mind, that is basically the reason why that is being stepped down. And of course, come to think of it, look at the National Assembly. You have a lot of state governors. What makes you think that they will pass such a legislation into law? So it's very interesting that we are discussing this, but I bet you the best approach would be to go back to the party structure level at that level so that you'll be able to determine who becomes what. And I think that it's a process, and I think we'll get there to that point where the votes of the people actually counts and the people are able to determine who governs them. All right, so I think that's my intervention for the question that you have asked. Moderator, is there any other question?
Yeah, we have Victoria. I don't know if she's still.
Is that the last question?
Yes, sir.
Okay, let's have Victoria.
Sorry, I forgot to lower my hand. Thank you. You've answered my question, sir.
Oh,
Okay.
yeah, I thought as much. All right. Sorry, do you want to give us a closing remark? That's the last question. Doctor, are you there?
Yeah, okay. So once again, I want to commend each and every one of you for your excellent participation and engagement. The questions you've asked are very germane, very important questions, very, very intelligent questions, I must say. We may not have addressed all. I'm sure that the comment section, the chat box may be replete with a lot of questions, but I think that from the interventions that we've had so far, we've been able to touch some aspects of whatever concerns that you have dropped on the chat box. And if there remains any that has not been addressed, of course, the Electoral College can always make those available to us, and we'll be able to respond to them, provide some robust clarification to that effect, which of course will be shared with each and every one of you. On a final note, I just want to say that what we are doing here is a very serious business, and which is the reason why we could commit the length of time that we have committed to this Electoral College. I'm really very excited being part of this process to share experiences of what we've done in the past, and based on participation in some of the discourses currently taking place in the country. And I hope that we will continue to maximize the benefits of the knowledge we have acquired here, to continue to broaden our horizon on political issues in Nigeria. Get involved. Whichever party is of interest to you that aligns clearly with your ideology, get involved and begin to contribute to national development. A lot of the people we have in office today, they've been in office since while they were in their 20s, and a lot of them are still there. We have a lot of people who are appointees of government who have been in politics all their life. In fact, the only thing they've done is being in politics. However, I encourage that, look, even if you must be in politics, have something that you are doing, okay, so that you can always fall back on that thing that you are doing when you are not holding any position, so that you don't become like the career politicians who have nothing more other than politics, and which of course is the reason why we find a lot of the kind of corruption that we have in the system today. So once again, I want to thank all of you, and I will hand you to the moderator and perhaps any senior member of the Electoral College to close us. Thank you once again, and God bless you.
Thank you, Doctor. Thank you so much. Thank you, as always. We appreciate you. May the good Lord continue to bless you, expand your horizon, enlarge your coast of knowledge. Thank you so much. We are highly grateful. Yeah, guys, we come to the end of the class for the week. And please make sure you keep tab on your group informations for any information while you prepare for the class for the next weekend. Thank you. Thank you. Have a nice weekend. God bless Electoral College. God bless the Federal Republic of Nigeria. God bless you all.